Roman numeral 1, definitions and scope of policy.
You know, the regulations, they always seem to start off with the important definition. So let's try the first one. The definition of virtual office website refers to a participant's internet website or a feature of a participant's internet website through which the participant is capable of providing real estate brokerage services to consumers with whom the participant has first established a broker-consumer relationship as defined by state law, where the consumer has the opportunity to search MLS data subject to the participant's oversight, supervision, and accountability.
Well, I think some key points there, and the first one is a website capable of providing real estate brokerage services. Now, it's interesting because to me, real estate brokerage services is a very far-reaching menu of services that are offered to a consumer, and yet, while they start out by saying brokerage services, providing real estate brokerage services, this whole document doesn't address brokerage services, it addresses one thing: listings.
Listings, residential properties.
Residential, it doesn't really.
Doesn't talk about property management or commercial.
Or transaction management,
right,
or things that you could foresee a broker would use a virtual, really a virtual office website. If a virtual office is really similar to a bricks and mortar office, then you're going to be doing a lot more there than just looking at listings, but that's never addressed. And so I think the term itself, virtual office website, is a misnomer. It's really a website that allows people to look at listings whether the listing broker wants them to see them or not.
That's right.
That's what it is.
Listing brokers themselves can't opt out of this, as we'll find out, like they can with IDX.
No choice. And so while you can call it that, that is a sham.
Mm-hmm.
Because nobody is setting these up as virtual offices. These are anything but virtual offices. Now, at the same time, like I say, you're not going to find even many of these that are set up, and it might be something whose time has come and gone for the most part. And but still, it's almost an insult for them to call it. If I were an active participating or an actual in the brokerage business today, I'm still a broker, but I'm not practicing, I would almost be insulted. Because there's so much more than the looking at data from the MLS that takes place in an office, bricks and mortar, and if it really and truly is a virtual office, which of course we know it's not.
But you know, they tried to get there. If you look at the definition, it says VOWs refer to a participant's website or a feature of a participant's
or a feature
internet website. And how long have we been working on trying to get Etransactions going? It's almost like 10 years from now. We have brokers that have their contact management on their websites now, and the Etransaction. So perhaps some people will try to stretch it into having a virtual office. So it's not just confined to the listings themselves.
And also, key point, and that is that subject to the participant's oversight, supervision, and accountability. Oversight, supervision, and accountability. How do you do that? How do you provide oversight to your virtual office, to your website? How do you supervise a website? Who do you supervise?
Yeah, it's going to relate to also further down in the scope of policy here. They're going to allow agents to have their own VOWs with the broker's permission, but for those that the broker is also going to have the same duty of oversight, supervision, and accountability. Now, who's going to set up the VOWs themselves? Subsection 1A talks about the participant can designate what they call an affiliated VOW partner. It's kind of a new acronym, AVP, to operate a VOW on behalf of the participant, subject to the participant's supervision, accountability, and the terms of this policy. I think that's similar to like with IDX, where you had IDX solution providers who would set up the IDX for brokers. And those IDX solution providers also had to have agreements with the multiple listing services and license agreements. So I think that's parallel to what we're used to with the IDX providers.
But once again, even with an AVP, it's still subject to the participant's supervision, accountability to the terms of this particular VOW policy.
Right. So if your AVP is leaking information, jeopardizing the security of the database,
using it for other purposes, selling that data, then the accountable party is the broker that hired the AVP.
Right. You're not just going to be able to give it to a third person and say, well, that's it, you take care of everything.
What kind of penalties would you think be in place for the broker who fails to correctly police their AVP?
Well, it could be fines under MLS rules and regulations. Could be suspensions, expulsion from the MLS.
Things need to be determined, though.
Yet to be determined. These are probably the things that, like Terry Penzo is going to be talking about, what they can do to enforce these rules. Under 1B, a non-principal broker or sales licensee affiliated with a participant may, very important, with the participant's consent, operate a VOW or have a VOW operated on its behalf by an AVP. Such a VOW, once again, is subject to the participant's supervision, accountability, and the terms of this policy.
So to put it in a more common language, if you're a broker and you have agents working for you, and you decide, because it's your choice as the broker, to allow the agents working for you to have their own vows, you can do that, but you're responsible. If, in fact, there are any violations, misuse of the data, you must supervise. It's like 10 o'clock. Do you know where your agents are? Kind of thing. It's like the broker. Now, we know brokers have always been responsible and have failed in many cases to really pay attention to the types of websites and the types of information that their agents have had on their websites, because they failed to have written policies about internet display and websites. So this policy, though, says clearly that brokers can authorize for their agents vows. Matter of fact, if you're a broker and you don't authorize it, that's your prerogative.
That's your choice.
But then know that your agent might leave you because that's a point of differentiation, and they might say, look, I need a vow to conduct my business, and you as the broker might say, I don't believe in this internet stuff, and so if you work for me, you can't have a vow. You might be chasing the newer generation of agents away from you because you do not allow them to have a vow. So those brokers that do allow their agents to have a vow might have a competitive advantage in recruitment over the brokers that don't allow it.
And just because you allow your agents to have a vow does not mean that a broker has to have their own vow. So a broker may elect not to have a vow, but as Saul said, there's a retention aspect to this that they need to be attentive to. The 1C, each use of the term participant shall also include a participant's non-principal brokers and sales licensees. With the exception, however, that references in this section to participants' consent, participants' supervision and accountability are going to be referring to the principal broker themselves. Each reference to vow or vows refers to all vows, whether operated by a participant, by a non-principal broker, or a sales licensee, or by an AVP. This is the scope of the policy. It extends not just to the participant, but across to the sales associates.
And it's like when the term participant is used in this document, it includes everybody.
It includes everybody, except where it says you must have the participant's consent. Then you're only talking about the broker. Number 2, the right to display listings in response to consumer searches is limited to display of MLS data supplied by the MLS's in which the participant has participatory rights. This does not preclude a firm with offices participating in different MLSs from operating a master website with links to such offices' VOWs. So the types of listings that you can display on your VOW are going to be the data that's supplied by the MLSs in which you have participatory rights.
Well, this is kind of an interesting one. I think we really need to kind of dissect it a little bit.
Okay.
The right to display listings in response to consumer searches is limited to display of MLS data supplied by the MLS in which the participant has participatory rights. Does that mean that your VOW can't have listing data or information that's not contained within your MLS?
Further on, it's going to say that you are allowed to put it in there, but you might have to have a separate search for that, and in all cases you must identify the source of where you got those listings if it's other than from the MLS where you have participatory rights.
Now, it also says that you could have a master VOW, and that you might be a member, and many brokerage firms today are members of multiple listing services. And you might have access to different MLS databases, but you can't mix them all together, I guess. You have to maintain them separately, but you can have a master page, like a landing page, that then has links to the VOWs in the different MLSs in which you are a participant.
I think that's a correct statement. But it's going to be one of those things where we're going to see how it's interpreted locally. Number 3, participants' internet websites, including those operated for participants by AVPs, may provide features, information, or services in addition to VOWs, including the IDX exchange function. So you can have both an IDX and a VOW. So what would be the advantage?
Well, so the IDX, remember, is a subset of the data. And the IDX is the data that the MLS, typically board of directors, decides is going to be made available to all the brokers to advertise on their sites. With a VOW, except for the specific confidential information, you get it all. And so the big difference in ID, at least the way I see it at this point, the difference in an IDX feed and a VOW feed would be the detail. You think?
Yeah, you can, and they're going to specify the types of data that you can include there that perhaps you wouldn't be able to include in the IDX. I think it's also related to the number 4, the display of listing information on a VOW does not require separate permission from the participant whose listings will be available on the VOW.
No doubt, that's a big distinction.
Permission, this is not an opt-in situation like we had with IDX. A broker has to participate if they participate in the MLS.
So if I'm operating a brokerage firm in a marketplace where I'm a small broker and another broker controls 60% of the marketplace, one brokerage firm controls 60% of the marketplace, that broker might decide to opt out of IDX and say, I'm not letting you put your listings on your website because I'm the biggest broker in town and I can get people to come to my website because I'm going to have 60% of the listings on my website and you only have 1/3 of 1% of the listings on your website, so nobody's going to go to your website. So why would I give my listings to you? No, I'm opting not to allow you to have your listings under IDX. Now, broker can do that.
And has done that in some areas.
And in some areas they have done that. And that small broker can come back and say, great, I'm going to create a VOW. And now I'm going to take all your listings and put all your listings on my website. And you can say no all you want, but you don't have the right to tell me I can't do it.
That's correct.
So let's read that one again.
Yeah, big distinction.
The display of listing information on a VOW does not require separate permission from the participant whose listings will be available on the VOW. So permission is not required to display another broker's listings within your VOW.
That's right. And with IDXs, permission, was through the basis of the
opt-in or opt-out.
Opt-in or opt-out. The last scope here, number 5, except as permitted in further sections 3 and 4, MLSs may not adopt rules or regulations that conflict with this policy or otherwise restrict the operation of vows by participants.
This is the rule.
This is it.
This is the law. And so that concludes Roman numeral 1, definitions and scope of policy for the policy governing use of MLS data in connection with internet brokerage services offered by MLS participants, parenthetically, virtual office websites. And again, we're having a conversation about Exhibit A of the proposed final judgment between the United States and the National Association of Realtors.
Which you will find in its entirety on our site.
Yes, if you go to internetlistingdisplay.realtown.com, in this information and more, and obviously you found the website because you're watching this video.